My name is John Strohmeyer with Strohmeyer Law. Thanks for joining us. We are answering your questions about retirement accounts today. So, if you've got a question, make sure that you drop it as a comment below. Don't forget to like and subscribe so you get all of our updates. And now we're ready for our first question. What do you mean by retirement planning? Isn't having a 401k enough planning? Well, I'm just a humble country tax attorney. I am not here to do retirement planning for you per se, so I'm not going to tell you what to buy or sell or how to invest your money. But things to think about are, well, you're going to hopefully get older. You're going to stop working at some point. We want to make sure that you've got money ready to go for that. So, as an estate planning attorney, why do I care about this? Well, what I'm thinking about is we want to know what you've got. You may have a 401k, and if you're putting money in there, you want to make sure that you've got that so that it's going to have things for you. You'll have cash for you to live off after you've retired. You're also going to want to think about Social Security. What can you get there? Any other savings you may have. So these put together are going to be part of your retirement planning. Making sure that you've got that all in place, working with a proper financial advisor, somebody who actually knows what they're doing, not some foolish estate planning attorney who really doesn't. That's what we want to make sure that you're getting the right planning done for you. So, by retirement planning, it really is making sure you've got the answers that you need to know when you retire, when you stop working. Will you have enough money to continue to live in your current standard of living? And we've got to balance that against, well, how much tax are you going to pay on the money that comes out of that? Where else are you going to be living? Just kind of thinking about, well, where's the money come from? So, next question. I have an IRA account for my retirement. What else do I need? So, first things first, IRA account is, say, put it a different way. An IRA account, well, it's an individual retirement account. So you don't need to say IRA account. It is just an IRA. An IRA is an account where you've set it up by yourself. It's not through your employer like a 401k is. The 401k, when you put money in there, you get the immediate tax deduction and it's run through the employer. The IRA is outside of the employer. There are limits on how much money you can put into these accounts. So, again, what else do you need? Depends on what you've got. So IRA, 401k, you may end up with both depending on what's going on with you and your current employment. So your employer probably gives you a your employer probably already gives you that 401k. When you leave, you get to take the 401k with you. You probably roll that over into an IRA. Again, check with your tax preparer and your financial advisors before you do that because there may be some tax consequences to that. So, what else do you need? Well, where are you going to live when you're retired? You're going to be taking money out of this IRA. When you put money in to the IRA, you get a tax deduction for that. So, you're not paying income tax on it. While the money is in there growing, it grows tax free. But when you start pulling money out of that account, when you're required to take minimum distributions from those accounts at certain ages, then you're going to pay income tax on that amount. So if you're required to pull out $100, you're going to include all 100 of those dollars in your income tax each year. How much are you left with? What else do you need? I mean, you've got to pull through, well, what's going to come out? How much are you going to have after you pay tax on those distributions? Make sure that you've got enough saved away so that you can have a comfortable retirement. Next question. What monetary thresholds do I need to take into consideration when setting up my planning for estate tax? Now, we start with the beginning where people say, oh, well, John, isn't the current exemption $12.06 million in 2022? Yes. And a lot of people then say, well, John, that might as well be $11 billion because I don't have that much. And that's fine. But we're talking about what levels do we need to think about. So the way the law is set up right now, that exemption amount, $12.06 million, it's actually $10 million as adjusted for inflation from 2011. So every year it's ticking up for inflation. It was $11.7 million per person last year. Next year, 2023, it'll go up and it'll probably be 12.2, 12.3 or so. So it's going to keep ticking up for inflation every year from now until 2025. When we hit 2026, under current law, the exemption amount is going to drop, and it's going to be, instead of $10 million adjusted for inflation, it's going to be $5 million adjusted for inflation. So that means in 2026, it'll be about $6.5 million. And with it being about $6.5 million, that's the number I tell clients to start thinking about, because we want to start thinking about how much are you going to have and where are you going to be. Now, for clients who don't think they're going to live into 2026, well, we're going to start using the $12.06 million number. Why? That's the amount that you've got access to. We're not really worried about it. When we think about most of our clients who expect to live not only into 2026, but well beyond 2026, those clients, we're thinking about $6.5 million. Why? We want you to think about what you're actually going to have. And we're going to start thinking through that. Now, I think about this in different kind of priority levels. It's kind of DEFCON level, going from 0, which is the lowest, no estate tax issues anticipated, up to level 5, where we're doing all sorts of crazy, complicated trust planning. So as we switch over and start thinking about these different levels, level 0, these are people who have less than $2 million in gross assets. Good news and bad news, we don't really have any estate tax issues for you. If you're less than $2 million, you're just not in the area where we're worried about you paying tax. Now, this is married or single, less than 2 million, nothing to worry about right now, unless you think there's some big, if you're just adding assets at a good clip, if you think you're going to come into assets, just at that level, we're not worried about estate tax for you. Now, move up to level 1. Somewhere between $2 million and below $6.5 million, at least for right now. It's what we call level 1. Here, estate tax, you could have estate tax issues if the law changes and it's going to drop, that exemption amount's going to drop below $6.5 million, or if you're going to have significant additional assets that push you over that threshold. Now, this $6.5 million, this is whether you're married or single. Putting your assets together, if we've got less than $6.5 million, level 1, we're just not really worried about estate tax for you. Again, good news and bad news. The difference being you've got more stuff. We do want to think about some of the income tax consequences of this, but we're not expecting any estate tax to be due. We're not expecting to have to file an estate tax return for you. Now, bumping it up, level 2 estate tax issues, we've got some tax to think about, but we're not really worried about payments. And this is where we start getting into the difference between married couple and a single person. This is a single person. You're going to start edging into this when you get closer to $6.5 million, but a married couple, you're really going to be in the current like 8 to 10 million range. Again, things are flexible. It kind of depends on where you are in life, how much you're spending. But just as a way of thinking about it, it's an amount where you're starting to put assets together. And if you don't do some planning, you're going to be making payments. So we do want you to think about this. So married couple with $8 million, John, there are 2 of us. Yeah, that's right. There are 2 of you. Even at 8 million and you have supposedly 6.5 in 2026, 6.5 million of exemption. What does that mean? You're still under it. But the problem is if you don't do any planning, you're going to have estate tax. Why? You pay estate tax on an individual basis. It's not a joint return at all. So you're going to want to think about, hey, this is the amount that's out there. We want to start thinking about this. It's limited planning, kind of minor movements that we need to make sure that you're not going to pay estate tax. So active management, if you get over the exemption amount, so if you're a single person with like 7 to 7.5 million, if you're a married couple in the 12 to 14 range, you can start making some gifts now, charitable gifts, testamentary planning, annual exclusion gifts. Those are those $16,000 per year gifts. These are people where we can manage that bill and bring it down to 0 with some planning, and you're fine. We may have to file an estate tax return, but again, we need to do a little bit more, but no real heavy gifting that we're thinking about. Additionally, we've got some clients who have tens of millions, and they're in estate tax level 2 because they're planning on zeroing out their estate tax bill by giving it all to charity. Everything over the limit, we're going to give to charity. So if They've got $20 million. They're single, and the exemption is 6.5 million. Well, that 13.5 million that goes over the limit, they're going to give that all to a charity. So that zeroes that out. 13.5 million to charity, 6.5 million going to not the charity, so kids, family members, whoever it is. No estate tax bill. We're going to have to file an estate tax return, but we're not paying anything. Again, the key there, we've got some estate tax issues at level 2, but we're not worried about payments. Level 3. Now, this is where we know we're already going to have to file an estate tax return, and we're probably going to have to pay something. So levels 3, 4, and 5, really what we're doing is we're looking at how much and what sort of planning do we need to do. Level 3, we can really solve those payment issues with additional liquidity. We're thinking life insurance generally. It's just it's going to be an estate tax bill. It's not so much that just getting another a life insurance policy may make sense, or making sure people have enough funds to pay the bill, because we don't want to go in and have to do a fire sale on assets, perhaps a closely held business, on a death. That's the important thing. We want to make sure that we are not dealing with liquidity issues there. Level 4, this is kind of more complexity. Well, we want to start thinking about fractional gifts into trusts. Level 3, the life insurance benefits are subject to estate tax, so we want to be careful to properly structure that life insurance so that it's not getting eaten. 40% of that is not disappearing into estate tax. Level 4, we're saying, well, we're going beyond that additional liquidity. We may own interests in closely held businesses. We're going to start thinking about taking those interests in those businesses and breaking it up, and maybe giving 5% here, 10% there, something to where we can get discounts on the business interests that are being gifted. People will start asking, well, what about a family limited partnership? Can we do that? You can. There are some complications with it. It's kind of beyond what we're thinking about today, but the fractional gifts as part of a family limited partnership could be used here. Finally, level 5, when we're getting into the really complicated stuff, this is, we know we're going to pay tax. We're probably already setting up trusts. We probably have some life insurance as well. We're thinking about split interest trusts. So this is generally where we have a trust for one group of people for a little while, and then a different group of people later. So some examples of this: grantor retained annuity trusts. This allows you to put assets into a trust. You, as the grantor of the trust, the person who created the trust, you're getting an income stream back for a term of years, meaning you put stuff in there, then you're bringing things back. So there's not a gift tax on that. Whatever's left goes on to somebody else. You're making a taxable gift to some family member. That's one way of setting it up. Another way of doing this are charitable remainder or charitable lead trusts. This is where you're splitting it between the benefit of that trust between a charity on one term and then your non-charitable beneficiaries. So a charitable lead trust, the charity gets a stream of income for a number of years or certain length of lives. Then after that time, it's going on for a non-charitable beneficiary. You're splitting it up. Again, because part of it's going to a charity, you lower the amount of the taxable gift. Other side, a charitable remainder trust, maybe you want to provide an income stream for a family member for the rest of their life, and then the rest of it, when they've passed, goes on to a charity. Again, because part of it's going to a charity, you're able to go ahead and split up what they're getting. You get basically a charitable deduction for that, because the charity's getting part of it. It's not all going to your family members. Lots of rules around it, but again, so again, those are some of the thoughts we have, kind of how we grade out how much estate tax you should be thinking about. So level 0, less than $2 million, we're just not worried about estate tax. Level 1, you've got some estate tax issues. If you and your spouse are going to be under, if you're in the $2 to $6 million range, we're thinking about really estate tax planning if you get to a higher level of assets, or if the exemption gets brought down. Level 2, where there are issues, but we've zeroed out the tax. We're not really worried about it. This is when you're kind of 4 million and more, and that gets into levels 2, 3, 4, and 5. So, once you need to start thinking about it, really is at $2 million. It's not, oh, I've got 11.01 million now I need to think about it. You want to start thinking about it well before then, even if you're not going to be paying any of that tax. So, next question. Do my retirement benefits avoid probate? So, usually yes, and let's get into it. Two types of broad categories for property when we think about probate. There is probate property, and these are assets that are covered by a last will. They're governed by the probate process. They're available to pay any creditors you have remaining. Non-probate property is anything generally that comes under some sort of contract right where the beneficiary, the owner of that property is going to be determined by some agreement that you have with the custodian. So this is things like state plans, life insurance, IRAs, 401ks, annuities. You may have a transfer on death deed. These are assets that once you have passed, they go somewhere else. So generally, these benefits are going to avoid probate. And here in Texas, it's going to avoid probate. It's going to zip over to whomever you've set up as the beneficiary. Good news about this, it avoids probate. Bad news about this is you want to be careful who those beneficiaries are. One of the big mistakes we see is parents of small children have named their children in equal shares as beneficiaries of their IRA or 401k. The motivation is correct. You want to make sure that your kids, if something happens to you, they can receive the benefit of your retirement accounts. The problem is, until your children reach age 18, they're not legally allowed to own that asset. And what's going to happen is that they're going to have to go through a guardianship. We're going to need a guardian of their estate to manage that asset. Even if even if only one parent has passed, somehow the kids got named as the beneficiary above their spouse, you're still going to need to go through and have a guardianship set up to manage assets for those kids. Again, we're managing those assets for the kids because they're minors, they're the owners, but they're not legally entitled to own that until they're 18. So be careful with your beneficiary designations. If you have minors on them, this can be a big issue. You can basically walk into an unforced error on having to pay for those that guardianship, which can be tens of thousands of dollars to get set up, thousands of dollars each year to maintain it. So yes, retirement benefits generally are going to avoid probate. The big problems are, one, you could have a beneficiary who is a minor or incapacitated, kind of mess up your planning there, or potentially you may have it go to the wrong place, and just be careful with it. Next question. What is Medicaid planning? So getting into an area of the law, Medicaid planning typically comes under what is known as elder law. It's similar, overlaps a lot with estate planning. You're helping folks who are thinking about, again, retirement planning. What happens once they have retired from work, they're past 65, they want to see if they qualify for Medicaid. The key with Medicaid is that it is a means-tested program, meaning the government, before they determine to pay any benefits to you, they're making sure you are under a certain level of assets, because Medicaid is not for everybody. It is only for people who need the help. And so a lot of planning goes into this. This is a specialized area of the law where we don't work with it. We have firms that we love to send this work to because it is specialized. You want to make sure that you're qualifying for Medicaid appropriately. So if you can get that, you do get it. So two types of planning for this. There is kind of first party planning, where you are bringing somebody in for Medicaid planning, where Medicaid is going to be for their benefit. You're looking to impoverish yourself so that you don't pay, you can qualify for those Medicaid benefits. You're also looking to make sure that you can, once you've gotten those benefits, you can continue to live and make sure that everything's going to pass on in the right way. The other type is third-party Medicaid planning. Now, this will typically be for parents of incapacitated children who need to be on Medicaid for the rest of their life. And the key is making sure that that child will get the benefit of Medicaid for the rest of their life to take care of their medical conditions. This is hard to get onto. You're on a waiting list as a family, And so the Medicaid planning, again, it's looking at who's going to get what and how can you qualify for this government benefit. Next question. What is a Miller Trust? So, Miller Trust is a part of Medicaid planning. Again, when you're doing Medicaid planning, you want to make sure that you can qualify for Medicaid benefits. Miller Trusts are basically set up so that you can you put your assets in these trusts, so you have access to them on your death. Medicaid gets to come back and get reimbursed for anything that's left. The idea is you can impoverish yourself to the point that you can get Medicaid. You're also making essentially a deal with the government that when you die, they're going to get repaid out of whatever's left in there. There's a lot of ins and outs with this where you want to make sure that you qualify correctly. Again, I may have screwed up some of the notes on this. So if you're looking for this sort of work, it's for specialists in elder law. The other thing to note, we talked about first and third party planning. Miller Trusts are for first party Medicaid planning. You're looking to get Medicaid for yourself. One of the things that's key there is making sure it's got that Medicaid reimbursement claim. What can happen and mistakes that have been made when parents set up these trusts for their special needs children, they may inadvertently add the wrong provisions that say, even though my child is on Medicaid, make sure Medicaid gets reimbursed for any costs. This is an unforced error. You're potentially taking assets away from the generation after that special needs child. You want to make sure that that Medicaid provision, the Medicaid repayment provision, isn't included when it's not needed. Now, that first party trust where you're setting up the trust for yourself, you're probably going to have that in there to qualify for Medicaid benefits for yourself. But if you're setting up trusts for somebody else, whether it's a child or a grandchild who's special needs, make sure that that provision is not in there. Otherwise, you're going to be repaying government assets when you didn't need to. Next question. Does my retirement account or life insurance information need to be written into my will? Now, generally, we don't like putting specific assets that aren't being given to a specific person in the will. So, short version, no. The point of this question, though, is well, when you die, all the information about what you own, where your 401k is, whether or not you had a life insurance policy with Northwestern Mutual or anybody else, nobody's going to know this. You want to make sure they know where to go find your stuff. So, a big part of the estate plan is where is your stuff? How will people know what you owned and where to find it? What we're doing in estate planning is not just, managing estate tax. It's not you've got your 7 Porsches and manicured gardens that we need to look out for. We want to make it not a mess for your family so they know where to go find your stuff and find it easily. So you don't need to put it in your will. Again, life insurance and retirement benefits aren't going to be governed by the beneficiary designations anyway. Or life insurance and retirement accounts aren't going to be governed by the will anyway. They're going to be governed by their beneficiary designations. So putting it in the will really is going to confuse things. Put the beneficiary designations to where they should go, whether it's an individual beneficiary, a charity. You may be naming a trust created in your will as a beneficiary of the life insurance policy or that retirement account. But it's what comes after that. It's making sure that people are going to have to practically find what you own. So go find it. Make sure there's a good list of assets. Doesn't have to have to the penny values, but just knowing this is where we can find stuff. That's the big thing to look out for. It doesn't have to be listed in the will. Heck, the accounts you have may not even be the accounts you own when you die. So you may be sending people on a goose chase. That's not what we want to do. We want to make it easy for people. So I still recommend having a good list of assets, update it regularly so people know where to find your stuff. That's every account. We don't need to know 3 pairs of red socks and 2 pairs of blue socks, but just knowing I've got all my stuff in my house. I don't have a storage unit somewhere. Make sure we know where to go find your stuff. And next question. Are inherited retirement accounts taxable to the receiver of the accounts? So, there are actually 2 questions in this. Is it subject to income tax, and is it subject to estate tax? Income tax, probably yes. Estate tax, probably yes as well. So, income tax number one, for an IRA, when a beneficiary receives that account, when you pass, they've been named as a beneficiary, it's passing on to them, is the account taxable to them? It is subject to income tax as they take distributions from the account. We got some changes in the the required distribution rules a few years ago. At this point, if you are a beneficiary, you're generally going to have to take that entire account out in 10 years. So that's going to be subject to income tax. Depending on your own personal circumstances, you may pull it out all in 1 year if the account is small. If it's a bigger account, you may spread it out equally over the 10 years so that you're not taking, you're not pushing yourself into a higher income tax bracket each year by taking out this higher distribution. Now, when you die as the beneficiary of the account, you will have pulled everything out of that account. Those will be subject to estate tax as well. Now, look, you may be under the $2 million threshold, $6 million threshold where we're thinking about estate tax planning, but it's something to consider. You're going to pull all the benefits out of this retirement account. It's going to be subject to estate tax in determining how much you have and whether or not you're going to have to pay any estate tax or file an estate tax return. So inherited accounts taxable to the receiver, generally yes. As you pull the money out, it's going to be subject to income tax. And when you pass, the assets that you have left, anything that's undistributed from the account, as well as anything you still own, haven't spent on your Maseratis or cigarettes or candy, that's going to be subject to estate tax as well. That was our last question. Thanks for joining in. Next week, we're going to be talking about international tax for individuals. So what rules do we need to think about if you are a non-resident and you're thinking about either moving to the US or investing in the US? Everybody, thanks so much for joining us. We'll see you next time.